Welcome to Springlaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. Springlaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Hello and welcome to today's webinar. I'm Stam, one of the lawyers at Springlaw, and I am joined today by our wonderful guest speaker, Anna Malazhavaya, a tax lawyer with Advo Tax Law. And I will properly introduce you in a second, but I'll just get things going here. Thank you to everyone for joining us today for this topic where tax and employment law cross paths. So it'll be a riveting conversation, I'm sure, but Anna's very good at unpacking it so that it all is English for us. So I'm always looking forward to speaking to Anna about tax. As many of you know, at Springlaw, we are employment and contracts lawyers in our Canadian virtual law firm. For those that are new to our webinars, feel free to ask any questions in the chat function. We're trying to leave some good time for discussion today. Feel free to download our slides in the handout tab. And finally, for more information about our firm, come and visit us at springlaw.ca, where we have a variety of resources, including our award-winning weekly blog post, our free policy compliance checklist, a link to our monthly newsletter. And you'll also note that Anna has a newsletter that you should be subscribing to as well, and I'll give you more information on that in a bit. And then information on our website about our innovative subscription program for employers and DIY legal products. About Anna, so she is our guest for today. I'm honored that she can join me in the middle of tax season. She's a trooper that she's even here, so I'm very grateful, thank you. She is the founder of Advo Tax Law. She's a tax lawyer who helps clients who are being audited, who are reassessed by the CRA to help resolve their disputes with the tax authorities. Anna represents her clients at the CRA level, at the Tax Court of Canada, and at the federal court. In addition to her tax litigation work, Anna advises her clients on a wide variety of Canadian income tax, HST, and international tax issues. She also helps business owners organize their affairs in the most tax-efficient manner. She is the founder of the wildly popular Facebook group called Canadian Tax Nerds, which is an informal discussion and study group of over 2.4 thousand Canadian tax professionals, with a very cool banner that includes a Game of Thrones picture. I noticed when I was looking this morning at it, and I thought that tax season is coming, and it's got Jon Snow facing the weather. I thought that was very good. And she is also a panelist at the weekly sessions of the Canadian Tax Club. So Anna, thank you very much for joining us. I'm delighted that you could join us today.
Thank you very much for having me. It's always a pleasure to be part of this wonderful webinar series. Whether it's tax season or not, I will find the time.
Thank you. Awesome. Okay, of course, before we start, I would like to acknowledge that we are on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Haudenosaunee, the Chippewa, the Wendat peoples, and that this territory is now home to many diverse First Nations, Inuit, and Métis people. Today is all about legal information, not employment or tax advice or legal advice otherwise. As lawyers, no conversation is complete without us giving this disclaimer. Here is a more detailed disclaimer that this is all just legal information for your, I would say for entertainment purposes, but no, for your business purposes. Okay, today we are going to talk about employers who are in Canada who have remote workers that work either in or out of Canada. So for anyone, for all of our attendees, and we have a good turnout today, we're really, there's a billion different topics that we could talk about in the world of where tax and employment law cross over, but we're going to try and focus in on Canadian employers who have remote workers that are working either in another province or territory in Canada, or who are working outside of Canada. And we'll briefly talk about the employment law piece around that, but then really spend most of the time on the tax implications of that. Okay, so let's start first with remote workers who are working in Canada for a Canadian employer. So I will just briefly set the stage for the employment law piece of this, and then I'm going to hand the mic over to Anna to really dig into what are the tax issues about this. So in this scenario, this is where you're a Canadian employer. Let's say you're in Ontario and you have an employee that wants to move to Calgary to go live with their family, and they want to start working there remotely, but for your Ontario operation. And like I've had that scenario so many times. COVID really gives rise to this all the time now. You know, presumably you have very good contracts that you're drafting and providing to your employees. If an employee is about to move out of province, then I think that is a moment to refresh the contract, because you're now offering up consideration to allow them to move and be remote wherever. But many companies now just hire people remote in the first place. And so here's just a list of sort of big picture topics that you'll want to include in a contract when you're dealing with remote workers. A remote worker policy, which would include a lot of these other terms as well, but really dig into the specifics of your company and what looks different around and what are your expectations for your remote workers. But you want to include things like, you know, returning equipment on termination, and then some of the other logistics that I have set out here. In all of your contracts, employers will always want to address location of work now, whether you're hybrid, in person, or fully remote. Having some term in there about location of work and whether or not it's optional, whether or not it's flexible. I like to have in there that if they're going to move provinces, that they really need to get permission first because of the tax consequences, and at least have good communications around that. Everybody will want to really beef up their confidentiality provisions for remote workers, especially if we're dealing with office workers with, you know, with highly sensitive information in their home office now. One piece that is sort of where HR and employment law blends is this idea of hours of work, availability, communication expectations. You know, in the world of remote working, and you know, I've had a fully virtual firm since 2017, and so these issues are something that we bake right into the upfront contract, and in our remote worker policy, and in our, you know, week-to-week meetings of expectations about when people should be around and be available. And so that there's just understanding about what that looks like, what platforms should they be, you know, checking in on, that kind of thing. For many employers, you may want to think about a timekeeping system so that you can really make sure you're meeting employment standards, especially if you have more frontline workers that are closer to minimum wage. You want to be making sure you're hitting that minimum wage. So having some sort of timekeeping system to make sure that people are earning the right amount, and then to have clarity if people are starting to work overtime and are only typically claiming it when you try and fire them at the end and they're annoyed at you. So having clarity around the timekeeping piece, and then just some logistics, you know, equipment. If you're providing equipment, what happens if the employee leaves for whatever reason, you know, resigns, terminated. Most of us need good home Wi-Fi to make sure that the whole thing even works remotely. And I know it feels like a given, but if you've got people that are living in more remote areas, you know, they've decided to move to their cottage in the Muskokas and work, they may not have great Wi-Fi. So it's actually something that you want to bake right into the contract. House insurance or renter's insurance is good. And then speaking to the issue of paperless, because remote really works best if you have a lot of good paperless systems in place. And talk through some of the things specific to your industry and your company. And finally, as a segue into Anna's topic, all employment contracts will have some sort of term that speaks to which province or territory governs the contract. And for employment law, it matters because where the worker lives is what employment standards will apply. It's largely the same across the country. You know, it's not great big dips from one area to another, but there are nuances from province to province. But identifying which province will apply to the contract, in addition to, you know, recognizing that if the employee moves to Alberta and you're in Ontario, you will need to figure out what the Alberta minimum standards details are. So over to you, Anna, to talk about what is the much bigger impact of taxes.
Thank you, Lisa. So I thought that the easiest way to explain the many wrinkles that may appear whenever you have workers crossing borders, either provincial borders or national borders, would be to use a specific case study example. And it may or may not be similar to what you face in your business or in your organization, but hopefully some things will be helpful, or hopefully it will make you think of the questions you need to discuss with your tax advisors. So in this example, we have Ahmed. He is a worker, a skilled IT developer. He works for Canadian IT Development Corporation, ITCO, with an office in Toronto and with headquarters in Toronto, Ontario. Ahmed lives in Calgary, Alberta, and he refused to relocate to Toronto, but he agreed to work remotely from Calgary. He currently works in his condo, but he has young children. The children are too loud. He gets distracted. He is asking whether or not you can rent a small little workspace or an office for him for $1,500 a month. And you're thinking it's not that much of an expense, really, given how talented Ahmed is and how much value he brings to the company. After all, you would worry less about confidentiality, and you wouldn't have to hear his children crying in the background every time you have Zoom calls or Google Meets with Ahmed. So you're seriously considering it. So, but before you do that, let's go through the tax implications you should consider and talk through with your tax advisor or your CPA if you have one. Lisa, I think we're ready for the next slide. So this is a decision tree, and as you can tell, I use different colors here. So let's start with the top left corner and the red square, where the first question you need to ask yourself is whether Ahmed is an employee or he's an independent contractor. And hopefully, you know, you've attended enough webinars by Springlaw to know that this isn't an easy question. Sometimes it's not that obvious. Sometimes it is, but that in itself is an important question to ask. It's not enough for Ahmed to have an employment agreement for the CRA to accept that he's an employee. Or it's not enough for Ahmed to have an independent contractor agreement for the CRA to accept that he's an independent contractor. You really need to look at the circumstances of the case. How much control you as an employer exercise over Ahmed? Does he set his own hours? Does he have a control to hire helpers? Is he eligible to any of the benefits, health benefits? Is he eligible to paid vacation time? All of these things will be important in determination whether or not he's an employee, and depending whether or on an independent contractor, and depending on whether he's an employee or an independent contractor, we have a different tax analysis. So if you see in my green squares is my analysis if Ahmed is an independent contractor. You can see that I only have two squares to consider, two issues to consider. Well, really one. If he's an independent contractor, I need to figure out the HST, GST implications. So presumably he would be invoicing your company, and that invoice has to have or doesn't have to have HST applicable to it, depending on the services Ahmed provides. There will be different implications. If Ahmed is an employee, you see there are two branches of the decision tree for you to consider and discuss with your tax advisor. The orange branch relates to your company, your organization, and there their tax implications, so withholding obligations. And the purple branch of this decision tree relates to the withholdings you may have to make in connection with the payments made to Ahmed. So let's look at the orange branch of this decision tree first. The first question we would need to consider is whether or not ITCO, which is our Ontario company, located in Toronto, whether or not it has a place of business in another province, owned or rented, or we call it a permanent establishment in another province. Well, immediately you would say, no, we don't have an office in Alberta. Our big office is in Toronto. But what about that little tiny office Ahmed asking it to rent for him so that you can, he can work in peace and quiet? That office is an office that may be viewed as a permanent establishment, place of business of your Ontario company in Alberta. So you have to carefully consider whether that, that meets the test. And if it does, then your accountants or your bookkeepers will not like you, because now they have to apportion the income that Ahmed brings to your organization and track profits and wages, apportion expenses and income, certain expenses and income to Alberta, as opposed to having everything in one place and have all your bookkeeping and accounting in one place. So that adds to a serious compliance requirement. Plus, you would have certain provincial tax obligations, which won't add to your total tax necessarily, but it will add to compliance and additional headache to your accounting bookkeeping team. So be careful there. Let's look at the purple branch of the decision tree. Now, ITCO is paying salary to Ahmed, and of course we all know that as employers we need to withhold the amounts on account of the future tax actual tax liability, CPP, AI, and all the social withholdings. Now, but what are the rates applicable in this situation? If Ahmed is in Alberta and ITCO is in Ontario, and as we know, the two provinces have different tax rates, different legislation, then the test to consider is whether or not Ahmed has to report to ITCO headquarters in person, whether there is that requirement is part of his engagement. If yes, then ITCO will have to make withholdings based on the rates of Ontario, the place of the establishment. And if not, ITCO will make withholdings based on the location. Sorry, if Ahmed has to if Ahmed has to appear to ITCO's headquarters in person, then ITCO must withhold at the rates of Ontario. And if if Ahmed does not have to appear at the ITCO's headquarters, then ITCO makes withholdings based on the location of its payroll withholdings, which is, in this case, will probably be Ontario. So again, a lot of things to consider. Different rules may apply when it comes to workers' compensation and other social, social payment legislation. And different rules may apply. So if you're familiar with Ontario legislation, but you have Ahmed working in Alberta, for example, especially if Ahmed is renting a space, or you, the employer rather, is renting the space for Ahmed in Calgary. It's time to see someone, an Alberta tax bookkeeping specialist, to make sure that whatever rates apply to the withholdings are the correct provincial rates.
So Anna, do I have this right, that there's business tax and then there's payroll tax, and there's each a nuance to both. There's a nuance to each of those when it comes to these location issues. So if the employee is 100% remote in Alberta and the employer is here in Ontario and they never have to fly back for meetings and they're 100% remote, then it would be the Alberta payroll taxes that would apply to that employee?
That's correct. That's correct.
And where is that tipping point of how, like, if they're reporting in person, and like, I can't help but think that this will somehow become obsolete one day, right? Because you can report in by video camera, and like as opposed to hopping on a plane and flying into Toronto and having a 1-hour meeting. That makes no sense to me. But what does in person mean? How much in person is required?
I agree with you. The rules were designed before COVID.
Yeah, or before like the internet got invented. It feels like.
I don't have a specific guidance for you as to how much in-person presence is required. So right now we're still watching that legislation developing, and we haven't seen a lot of specific examples from the CRA in the post-COVID world. But the main takeaway here is that as soon as you have an employer closing provincial boundaries, my advice would be to speak to a specialist in that province,
Okay.
and a tax specialist, and so, or at the very least, connect the two specialists, one in Ontario and one in Alberta, and ensure that you're not breaking any rules.
So before we move on to the next section about a Canadian employer having remote workers outside of Canada, as anticipated, we've had a few questions come through. So I'm going to start asking some questions. This idea of a permanent establishment. So if the employee, let's assume that we're all talking about employee stuff instead of a contractor. If the employee is in their home office, will that ever be considered a permanent establishment?
It's quite unlikely, because a fixed place of business or a place of business implies that the employer would exercise a certain degree of control over that space. With the home office, it's probably unlikely that your boss can show up at your home office and can tell you how to organize it, or how to paint it, or which furniture to use, and they don't have access to it, and they don't have enough control over that space. They don't rent it, they don't own it.
Right, okay.
In my example of Ahmed, who is asking for a small workspace room, the employer will rent that room. So that definitely tips the scale towards the permanent establishment situation.
Okay. Another good one. If so Ahmed lives in Calgary, let's say, and he has his home office, and he is like just an office worker, but the company happens to also have a warehouse in Calgary. Does that end up establishing a permanent establishment for Ahmed, even though Ahmed doesn't go into the warehouse? And Lena, tell me if I got your question right. I'm elaborating on your question, but I think that's what you're asking.
PE in province is a determination that you would have to make. So the CRA would generally defines it as a fixed place of business, which includes an office, a branch, an oil well, a farm, a workshop, a warehouse, or a mine. So a warehouse will be considered a permanent establishment in another province.
Even if Ahmed never goes there. So for his purposes and the taxing of Ahmed himself as a remote worker that only reports into the Toronto office, for example, but there happens to be a warehouse. I mean, I would assume there would be some interaction.
Would be probably serviced by someone, maybe another employee. So normally companies that do have a warehouse, they will have some presence in terms of people servicing the warehouse. But definitely this is a situation when I would explore whether or not that warehouse creates a PE in another province.
Right, okay. And then another question here from Winston related to this. If the employee has to report to someone in that PE, like in that warehouse, then would Alberta withholding taxes apply to Ahmed?
That's correct.
Yeah, because they're being connected to that warehouse.
Yeah.
Okay, I don't want to paraphrase in case I'm paraphrasing incorrectly here. Here's one from Natasha. If an employer's employee work on the road and live all across Canada, would you tax them based on their home address or the head office location?
That's a good question. So that probably, if that's an employee that doesn't have to report anywhere, then the location of the payroll office of the employer. So in Ahmed's case, that's the location of the Ontario payroll office. That would be appropriate rate.
It's my fantasy one day to go live on the road in a camper van. So my Instagram feed always gets full of all these like families of 12 children living in a camper driving across, North America. So they would have really complicated tax implications, I'm guessing. Although I think they make all their money off of Instagram of their children. But I feel like this is, the people who are really truly nomadic employees. That becomes a whole other story. If they're truly on the road with no fixed address.
Yeah, the smartest people I know, they schedule their travel in a way that creates a residency for them in a very low tax jurisdiction, or no tax jurisdiction. So they stay there just long enough to maintain that residency, and then the rest of the travel they spread between Canada or US or Europe or South America. And even though they make all the money off Instagram or whatever else they do, they pay no tax.
And you know what? COVID was horrible. Like, there's no doubt it was a horrible, horrible thing for the universe. But one of the upsides is this nomadic flexibility and just this push in technology that's really, I don't know, it's forced us all to rethink where people are going to live, for sure.
But you were COVID, right?
Yeah. Andrew, you had a question earlier that I wanted to do all the tax stuff first, but I'll just answer this quickly. You asked about home or renter insurance, why include it in the contract, and how will it affect the employment relationship. So I do always recommend, if it's a purely remote position, to include that in there. Just so that there is a base floor of liability mitigation. So if their house burns down and they've got a whole bunch of paper documents, or all the equipment gets stolen, is there some additional line of insurance to deal with in the home? Or not additional line, but any insurance in the home that can help. And renters insurance is not that expensive either. Many renters have it anyways. So I wouldn't recommend requiring additional sort of corporate level home insurance at all. It's just evidence of regular insurance, so that if any of the usual fires, theft, those kinds of things happen, then you have that. Workers' comp is a whole other story. Anna, you mentioned that briefly as well. For many home office workers that are just sitting at their desk with a computer and doing some phone calls, which is a lot of us, workers' comp isn't even required in that kind of situation. So a workers' comp is a whole other session that we could do. But so it depends on what your worker is doing. If they're doing something, if they're like drilling the oil sands in their backyard, you would want a whole other set of insurance and workers' comp type things attached to them. But for plain, regular office workers, it's a much more narrow range of things that you would need. And anything else to add to this section, or are we ready to go to the next one?
I think we're ready to go to the next one.
Okay, so this is remote workers working for a Canadian company in a beanbag on a beach outside of Canada. What does this look like? So let me just again set the stage for the employment law piece. The contract terms are almost the same. There's not going to be a lot different if you're a Canadian employer with workers abroad. You're going to have a lot of these same types of things. The two big differences, I mean, there will be nuances, of course, right? That will depending on where they go. But if they're like moving, if your company is in St. Catharines and they're moving to Buffalo, there's not going to be a great big difference in how they're going to conduct their work. But for some issues that might come up is who's going to pay for moving costs, especially if the employer is requiring or asking someone to go elsewhere to maybe be a scout in a new area for sales or open up a new office somewhere. And then are there cost of living differences at which you may want to consider or be prepared for the employee to push back on if it's that much more expensive. If you're from a small town in Northern Ontario and you're requiring the employee to move downtown New York City, there's going to be a significant cost of living difference there that you're going to have to adjust in your contract overall from compensation. When it comes to, so all the other things, timekeeping, logistics, all that stuff is going to be largely the same regardless of where they're working. Wi-Fi, you'll want to keep a close eye on where they're going. Sometimes time zone issues you may want to include. I should have highlighted that actually around the availability of hours. If you want people to be available, even a much smaller window, but some window so that there's concurrent communications. But the one thing that I would highly recommend putting in anything, in any remote worker contract outside of Canada, is to write explicitly in there that they need to go seek their own tax advice, because their tax interests by definition will be different than the employer's tax interests, and they need to seek that advice. Don't let your HR people be giving out tax information. Have them go and seek their own tax advice on this for sure. And while the company also seeks their own tax advice. And so you definitely want to have that in there, because this is where it starts to get complex. We're now crossing national borders, and this is where I will hand it over to Anna. One quick note actually before I do that. I have not broken this down in either of these slides between independent contractors and employees. And Anna's decision tree, there's a big difference, where if they're an employee or a contractor from a tax point of view, obviously. For many of these terms that are specific to remote working, it doesn't really matter if they're an independent contractor or an employee. So initially I had, drafted the slide to separate it out, but there was so much overlap between them. I just collapsed it all into, if you have a remote worker, whether they're an employee or a contractor, most of these things will apply, but there will be differences between the nuances between the two. How you compensate them and how you deal with tax, those are very different. But these sort of how we work, whether you're a contractor or an employee, will have a lot of overlap for the purposes of this discussion. But let me hand it over to you, Anna, to talk about more about what this PE looks like in a different country.
Okay, again, we're coming back to the concept of permanent establishment. When we cross borders, we are now dealing with different definitions of permanent establishment. So again, that previous definition that I quoted before that applied to a PE in the province, that doesn't apply any longer. And really the concept of PE becomes relevant in the context of a double tax treaty. A double tax treaty is an international agreement between Canada and different countries, including, of course, our closest neighbor, the United States, that ensures that nobody pays tax twice. So whenever there is a situation that would potentially give rise to tax in both countries, these treaties say that try to specify that, in this particular scenario, country A will have the first turn charging tax, and in this particular scenario, country B will do that, depending on the situation. So the reason the concept of a permanent establishment becomes important is that whenever you carry on a business in a different country, technically, potentially, it creates tax filing and tax liability implications. So I think in this case, we will have an example of Barb, a Canadian worker who works from her beach house in California for her Canadian employer. We all feel jealous of Barb, but nevertheless. So Barb, as she's working for her Canadian employer, that may be enough for us to say that the Canadian employer is carrying on business in the US. That may be enough for the Canadian employer to now have to pay tax returns, pay taxes in the US. But luckily, we have this treaty. And the treaty say that if you're carrying on business in the US Canadian organization, it's okay. We may not want you to pay tax in the US as long as you don't have a permanent establishment in the US. So it's a much higher threshold. Carrying on business is a very low threshold. It's enough to just carry on some business activity, talk to clients, make sales, advertise, or really simply working in a different country. So the very low threshold for PE is a higher threshold. So the treaty says, if you simply carrying on business, we may not go after you. We won't need your tax. But if you have a PE, we think you've established a strong enough connection to our country, the US, and now we want to tax you, and now we want to impose all these obligations on you. So there are different rules, different definitions, or different types of permanent establishment under the Canada-US Treaty. The first one is quite similar to the definition I read to you before on what is a PE in a different province. So a Canadian business will have a PE in the US if it has a fixed place of business, including a place of management, a branch, an office, a factory, a workshop, a mine, oil, a gas well, a quarry, or any place of extractions of natural resources, and some other, highly specialized, establishments. There are also DMP tests in the Canada-US Treaty, and that test says that you will have a DMP if you have a person working in the US and that exercises an authority to conclude contracts in the name of a Canadian organization. So it's almost like an agent P. If you have an agent traveling throughout the US, entering into contracts with US customers, organizations, that may push you into PE territory, even if you don't have a fixed place of business in the US, even if you don't have an office with the name of your company on it. And then we may have services fee. So if you have an individual present in the US for more than 183 days in a 12 months period, and that person brings more than 50% of gross income to your company, you may have a PE in the US. That usually makes some law firms really worried, as they have their key partners or key employees, key associates working from other countries and bringing a lot of revenues, even if they work from home, even if that law firm doesn't have an office or any fixed place of business in the US. And then we have the enterprise test, which means that services are provided in the US for more than 183 days in 12 months period, with respect of the same or connected projects for customers who are residents in the US or who maintain a PE in the US. That normally applies to a larger organization with a substantive project in the US. So again, all those the details will be important to your tax advisor as they look at different circumstances. So let's move on to Barb, who just has her little computer and in her beach house, and she is working for her Canadian employer. So she in Ontario. So first of all, we know that Barb is Canadian. How do we know that? We know that, she has a Canadian passport. We know she's a Canadian citizen. So that should be enough for us to say that she's Canadian for tax purposes. Maybe, maybe not. So if Barb is staying in California long enough, or if for whatever reason she also has a a U.S. passport, that may trigger some U.S. tax implications. That may mean that she's a U.S. resident for tax purposes. And if that's the case, then the analysis will be completely different. So if Barb is a non-resident of Canada, if she is a resident of the US under Canada-US treaty, and that's a different determination that your tax advisors, Barb's tax advisors, really would have to do, then our analysis will look the following way. If Barb is an employee of a Canadian company, and the Ontario company likely won't have withholding obligations as she makes payments to Barbara, but she will still the company will still have to issue a T4 to Barbara, and they may likely have U.S. withholding obligations. So it probably will be a situation, because Barb is a resident of the U.S., no Canadian withholding obligations, but U.S. withholding obligations, and therefore a U.S. tax advice may be required if Barb became a resident of the U.S. And like I said, she may become that tax resident of the U.S. even if she's a Canadian citizen, even if she is a Canadian permanent resident. Her immigration status is somewhat relevant, but it's not determinative to her tax status in the US. So that's a different determination Barb's tax advisor will have to make. If she's spending a lot of time in the US. Of course, if she's there for a month or two, you probably shouldn't worry too much. But if we're talking a more permanent arrangement, you need to start asking yourself whether or not Barb now becomes a resident of the US for tax purposes. If she is an independent contractor for whatever reason, and the CRA decides, then our only concerns is HST, GST implications. So if she is invoicing the Canadian employer for her services, then your tax advisors will have to advise you whether or not HST or GST is payable on those invoices. Will rather advise Barb. And here there are very complex rules, and I see that somebody asked a question, what types of services are exempt from HST for independent contractors? The answer is most services are subject to HST GAC. However, something else that becomes relevant is a place of supply. So if the place of supply is a location outside of Canada, that whole service can be exempt from HST. But the place of supply is not easy to determine. Just to give you an example, when I provide a consultation to, say, a non-resident client, the place of supply is deemed to be the location of the client. However, if the same client engages me to, say, file a document in an Ontario court, the place of supply becomes Ontario and the service is no longer exempt from HST. When we're talking services provided to people in between provinces, Alberta, for example, only has GST, 5%. They don't have HST. They don't have the provincial component of the tax. So whenever I have a client in Alberta and I'm providing advice to a client in Alberta, the applicable rate to my services, if the place of supply is Alberta, is 5%. The applicable rate to the same client, if the nature of the services is such as the place of supply becomes Ontario, the place of the applicable rate becomes 13%, which is the HST rate in Ontario. So things can change depending on the nature of the services, depending on the location where your client is located, and depending depending on that very complex determination, which we call a place of supply. So depending on what Barbara does, her services can be exempt from GST, HST, or if she does something that really creates a place of supply in Ontario, it may be still subject to HST. It's rare, but it can happen. Mm-hmm. Now, if Barbara is still a resident of Canada, and she works from her beach house in California, again, we need to think about withholding obligations on the payments to Barbara. If she's a resident of Canada, if she pays tax in Canada, if the Canadian Revenue Agency knows that they can go after her and they can go after you, and it's your tax withholding obligations on the payments of salary to Barbara won't be very different. As far as the CRA is concerned, if she's a Canadian resident, you're a Canadian resident, everything stays the same as if she was in Toronto. But here again, remember the discussion we had about Ahmed and his little rented office that he wanted. Same considerations applied. If Barbara works from her own beach house, probably you won't have a PE in like a place of business, a fixed place of business in California. If she wants to rent her own, if she wants you to rent a little office for her, I would stop and think, because definitely that would create a PE, that would create serious compliance obligations in the U.S. And maybe even tax obligations, because in California especially, we need to consider not only federal and state tax, we need to consider city taxes, and their tax system is even more complex than ours, if you can believe it.
Okay, the takeaway for me is that there's so many nuances. Nobody should dabble in tax, first of all, so call a professional. But being able to issue spot where there may be triggers of when you now need to go to talk to someone. I think that's I hope the main takeaway here. Lena has a good question here. What if an employee wants to just work abroad temporarily, like an extension of their vacation? How long can we allow them to work from another country before it becomes a tax problem?
Very good question. Every country will have their own rules on when they consider people their residents. So in Canada, for example, you are deemed to be a resident if you stay in the country for more than 183 days. You also can be considered a Canadian resident if you have a lot of ties with Canada. There are all kinds of case law of Canadian professors who have their homes, their families, everything in Canada, and then they go abroad for a year and they want to say that, well, I wasn't here for 183 days, therefore I'm not a resident of Canada. CRA says, oh, you are. We want your money, we want your taxes. So I can speak of Canadian residency rules, but I do know that every country have their own set of rules. Generally, they're connected to your physical presence in the country. Generally, for most countries, it's around half a year mark where after spending there for more than half a year, you consider the resident. But I cannot advise on other countries' tax rules, so the safest thing to do would be to connect with a local tax advisor. Something like a month or two probably won't make you a resident in most countries, but if you want to be safe, speak to the local tax professional.
This is my question. So Barb and her beach house, if she owns that beach house in California, does ownership make a difference or not at all? So she now owns property in California and she's going to stay there, let's say 5 months of the year. So she's sort of under this half year, I was going to say threshold, but I know we can't advise on California law, but let's say it's about 5 months of the year. She lives in her owned home, beach house in California. Does that have any impact or it's irrelevant?
It's somewhat relevant because remember how we were trying to establish whether or not Barb is a resident of the U.S.
Right.
And we're saying we don't know, but that the fact that she owns a home available to her in California will be relevant for the treaty tiebreaker rules, or for the determination whether or not she is a resident of the U.S. for the treaty or for the purposes of the treaty, or whether or not she's a resident of Canada. So it will be relevant. It doesn't mean necessarily that, oh, now she's a resident of the U.S., but it's one of the many factors that are relevant.
Yeah. Okay. A question that we are regularly getting since, post-COVID and a little bit near the end of COVID is, just a small, it could be tech, but some sort of office worker, knowledge worker company where they've got an employee that wants to just go, rent an Airbnb wherever for 3 months. If it's a shorter period of time, you're saying that the employer probably doesn't have a ton of tax issues, subject to whatever may be in that local jurisdiction. I think that's always a thing that they just have to get connected with. But from a Canadian tax point of view, if you have an employee and from the employment law perspective, you want to paper that a bit and have expectations and all that kind of stuff. But if it's for a shorter period of time, that's not the issue. It's when we start renting something in that other jurisdiction, whether it's another province in Canada or another country, or they start to stay longer than a few months. And then we start to get into whether we're establishing a business in that other country.
That's exactly right. I would also add to that list of issue spotting, whenever we start, entering into contracts into a different jurisdiction, of the Canadian employer, whenever that remote employer starts generating a very significant revenue for the Canadian employer, so significant that it may be viewed that, while working somewhere else in the little Airbnb, All the revenue originates from that brain power in that Airbnb, inspired by the beauty of the surroundings. So, so you're absolutely right. So, the trigger, the things to watch out for is longer stays, more than regular, vacation a month or two. Also, regardless of the length of the state, location, rented accommodations, or rented office. Also entering into contracts and revenue, or large amounts of revenue generation allocated to that employer. So this is what I watch out for.
Yeah, okay. Shawnee had a quick question here. It was back on this slide here. Brokers are excluded. Where was that? Was it in this one? No, where was it that there's an exclusion around brokers? Was it maybe in the last section?
A service,
it's
here.
Yeah. So the question is, what does that mean? Like, why are brokers excluded from this? It's this middle section on deemed PE test. Why are brokers excluded?
It's an exclusion that in the sense that if you have, let's say, a realist, a licensed broker representing or servicing a business in another country, that doesn't necessarily create a PE for that business that uses the services of the broker. The broker is considered to be a more independent entity. But whenever you have let's say, a marketing representative who is soliciting business in a different jurisdiction, that may attract that definition. Okay. And then there's going to be a billion layers of nuance there that I think they would need to just talk to someone, but that helps to understand that it's that more indirect thing. Okay, well, let's move forward into our key takeaways. The most important thing from a tax point of view, and it still remains important from an employment law point of view, is start with that employee versus independent contractor analysis and really figure out what is the actual, what is this worker? Are they a contractor or an employee? Lots of different things flow from each of those statuses. Know when you're establishing a permanent establishment, follow the movement of the money across borders. There will always, not always, usually be a tax impact if money is moving across borders. And as you know, Anna wrote these ones, not me. So I'm speaking on your behalf right here. But really, I think the big thing is, I'm hoping, these sort of cross-pollinating sessions that we have with lawyers in other areas is to help issue spot for our, employer and HR clients to know, okay, this is no big deal. Someone wants to extend their vacation by 2 weeks in Florida and work from there. Who cares? But as soon as they, move in with grandma and live for 5 years in Florida, it's a difference. And they start like generating all the money and, contracting on the company's behalf in Florida. Then you need to talk to a tax lawyer. So hopefully the issue spotting here is nice and clear. Any other key takeaways that you want to throw into the mix here, Anna? My third point is is my favorite point to repeat to everyone. So whenever you have money crossing borders, it doesn't hurt to pick up a phone or to talk to your CPA. Talk to your CPA, like as an organization. You probably have your CPA, your licensed CPA, and your CPA is probably more than qualified to answer your questions. You don't need to engage a lawyer or to pay lawyers every time. But every time you have a new arrangement with money crossing borders, chances are it will have some tax impact. So just pick up a phone, talk to your CPA, and if they tell you, nothing to worry about it, great. But there's also a chance that they will have some suggestions for you, or they will say, don't do it, this is no good, not a good idea.
Exactly. Okay, awesome. I want to do a very quick plug for this new offering that we have in 2024. We have rolled out our 2024 compliance program where we really help businesses simplify their must-have HR law components. We'll work with you to just update all of your mandatory HR law compliance policies and procedures, help you get your employment contract and termination documents fully up to date with how fast the case law is moving recently, plus a quarterly one-on-one with your designated lawyer in the firm to help just chip away at the overall annual project over the year to just help keep you on track and answer any HR law compliance issues you may have. Come on to our website if you would like more information about our compliance program. Okay, and that is right on time here. Thank you very much, everybody, for joining us on our webinar. Thank you, Anna, for all of your wisdom. I'm very grateful for you joining us. Our next webinar will be on April 17 at 10:30 a.m. Eastern Standard Time. We're going to be talking about the duty to accommodate with a focus on mental health and disabilities, which is a very, very robust and lively area post-COVID. So it will be hosted by our Springlaw lawyers, Marnie Baisley and Lexa Cutler. Feel free to follow up with any questions you may have. I think we got to most of the questions in the chat, but if we didn't, please reach out. For more information, come to our website at springlaw.ca. Go to Anna's website at avotax.ca, right, for yours?
Taxlaw.ca.
Okay, avotaxlaw.ca, sorry. And we will be sending out the link to the recording and to the slides with more information about Anna in a follow-up email, so you will all get that shortly. Thank you very much, and we'll see you next month. Thank you again, Anna.
Thank you for having me, as always.